Just a quick note, this is a free seminar sponsored by the NCBA. We're delighted to have you here. A quick plug for the administrative law section of the NCBA. You do not need to be an attorney to join. We welcome anyone who's interested in administrative law, and we have an associate membership option available for all rulemaking coordinators who are interested in joining us. Section membership really is very valuable for folks in the administrative law industry. It includes great continuing education courses. In fact, we've got our annual CLE coming up here March 18th, which will include a legislative update. It will cover significant state and federal case law updates over the last year. It'll have a session on the First Amendment and professional licensure, and also a session on AI. We're particularly pleased to be able to announce a session with both Brian Liebman, the North Carolina Codifier of Rules, and Jake Parker, who is the current Rules Review Commission chair. Our CLE that day on March 18th will conclude with ALJs and others sharing practice tips for how to best practice in OAH's administrative hearings. So please mark your calendars and attend if you are able to do so. For today, our Rules of the Road webinar, we're going to focus on two rules that the APA requires every agency to have. We are very fortunate to have with us Jeff Gray, our speaker, who is well known in the administrative law community. Jeff is a former chair of the administrative law section. He's also the past chair of the NCBA Government and Public Sector section. Jeff has advised North Carolina occupational licensing boards for many years, and he also represents licensees before other occupational licensing boards across the state. So thank you, Jeff, for being here. Just a quick announcement, this session will be recorded. The Bar Association will send out a link to the recording for attendees after the session today and to all section members within the next week. We will also send out Jeff's PowerPoint presentation to attendees. And if you have any questions during the presentation, please do put them into the chat function of the Zoom meeting. I'll monitor that, and as we have breaks in the session and toward the end of the agenda, we'll make sure we get those questions to Jeff for his feedback. If we run out of time and don't get a chance to get to all the questions that may be posed today, you're welcome to reach out to me or Jeff directly so we can talk offline about any issues you may be facing. There will not be a Rules of the Road presentation in March because of the CLE that we just discussed here. But we will update future Rules of the Road communications via email and topics as well. If you have a particular topic on your mind that you think would be very helpful for our group to consider and present, we'd love to hear it. So you're welcome to send that to me, to Ann Wall, or to LaSarah Carter, who is our staff liaison through the Bar Association, for this presentation. So with that, I'm going to turn it over to you, Jeff. And thanks again for being here.
Great. Thanks, Catherine. I appreciate it so very much. And I really am excited to be here. This is kind of a unique niche topic, but I think everyone here is involved in one way or the other in rulemaking, or you wouldn't be here. You'd have to be a pretty tortured soul to take an hour out of a Friday to listen to a rulemaking webinar if you didn't, for some reason or another, have an involvement with rulemaking. I'll add a couple of things to Catherine's introduction of me, which I deeply appreciate, Catherine. Thank you. For those of you that are rule makers, I am the rulemaking coordinator for 3 boards. So I've suffered along with you. And the next thing I'll share with those that I don't know here online today, I do hope that everyone's audio is on mute, because I will admit that I once served on the Rules Review Commission. I served 4 terms on the Rules Review Commission, so anyone that wants to boo and hiss, please mute your microphone. But I really enjoyed it, learned a lot. But as I will admit here in a few minutes, as much as you think you know about administrative law, and as long as I've been involved in administrative rules, this webinar actually came about by me discovering that I had overlooked something for 2 of the boards that I represent, and I'll tell you a little bit about that here in a moment. But today's focus is on two mandatory rules that all state agencies subject to 150B are required to have. There are others, and we'll touch on a couple of more that are elsewhere. There's one more in 150B, three in 93B, and lots of mandatory rules in various agencies. One of the more interesting things that I've seen over the last 10 years as I have monitored administrative law in the legislature in all the various capacities that Catherine mentioned, is the fact that as much as the current leadership, and I say current, say the last 10 to 12 years, but current leadership of the legislature say they don't like administrative law or don't like regulations or don't like occupational licensing boards. It's been amazing to see how many times in a bill in the legislature that they order the state agency by and through the legislation to promulgate rules. And that was not seen very often years ago, but is very common now. So there's more than just these two, but we're going to talk about two interrelated rules today. The first one is 150B-4 regarding declaratory rulings. And then the second is 150B-20 about rulemaking petitions, which are more likely to see. Some agencies see a lot of rulemaking petitions. Some agencies see none. So we've got a variety of folks here today, and I'm going to try to cover a little bit of everything for everybody as we go through this. But in the rulemaking, you'll find that some state agencies actually combine the two requirements in the same rule, which makes it a little cluttered, but there's no reason you cannot. But you'll see some similarities in the wording, so you can see why somebody has, or why a state agency has chosen to do that. I do want to point one thing out before we start first into the declaratory rulings. There are non-lawyers on here, and there are, of course, attorneys who represent the various state agencies with us here today as well. But there is a difference between a declaratory ruling and another phrase or term we hear quite often, a declaratory judgment. Declaratory judgment is obtained through the court system, district or superior court. Obtained through the court system, it is binding. It can be on any variety of topic areas that would come before the courts, and it is binding. A declaratory ruling is unique to state agencies, and oftentimes folks mix those two terms up. I'm going to go ahead and start sharing my screen with you to show you the first statute on this topic. And I hope,
and then we gotta go get Bummer.
and has the screen share come up for everybody? I hope so. If not, Catherine or somebody, LaSarah, unmute and let me know.
We can see it, Jeff. That's great. Thanks. And just a reminder for those who are listening in, please do mute your phones if you can. Thanks.
Okay. This is Article 26 of Chapter 1 of the General Statutes is your declaratory judgments. So that's not what we're talking about here. We are talking about declaratory rulings under 150B-4. So here's our language. Declaratory rulings. It's on the request of a person aggrieved. For those of us that work with 150B every day, especially in the area of hearings, Article 3 or Article 3A, person aggrieved is a term that is defined in 150B of what constitutes a person aggrieved. But as we go through these rules, you'll see that some agencies' rules leave it open to an interpretation that it can be most anybody. But on request of a person aggrieved, an agency shall issue a declaratory ruling. It says shall. And you will find that one of the things that we're going to dwell on today is the fact that the procedures and how the agency goes about determining whether to issue a declaratory ruling is very specific. So that shall may not be as mandatory as it sounds. But the line highlighted, of course, is what we're talking about today. The agency shall prescribe in its rules the procedure for requesting a declaratory ruling and the circumstances in which rulings shall and shall not be issued. It's that latter part of the sentence that I'm talking about that sort of modifies the shall above. Already before we this webinar started, I'd already gotten a question about what about state agencies that are exempt from rulemaking. And as we all know, having been students of 150B, that a lot of state agencies are exempt from rulemaking. Well, there's, of course, two answers to that. You're either subject to 150B-4 or you're not. But it says an agency shall issue. I don't know what the question is. The question's never been determined by the courts, so I can't say for certain, but I think the best argument is no. If you are in a state agency, if your state agency is not subject to rulemaking, you would not be subject to a statute that requires you to promulgate a rule. I think that not only makes legal sense, but it also makes common sense. But as you scroll down through the statute, you will see the basic requirements. The state agency has to give an answer, yay or nay. We are or we are not going to give a declaratory ruling. If they say no, then it is subject to judicial review by petition for judicial review under Article 4. If they say yes, they are going to issue it. They have 45 days to do so. And then if they don't do it within the 45 days, that is subject to judicial review. Now, I want to pause here a moment and share with you a really unusual case, and that is the North Carolina Board, the North Carolina Chiropractic Association versus the North Carolina Board of Education. This had to do with physicals, athletic physicals for the school systems, and whether or not chiropractors could do those physicals. This case was from 1996. Very interesting case because the School Board Association, or the school board, North Carolina Board of Education, said that they would promulgate a rule, which meant yes, yay, we're going to do it, not a nay, but a yay, and then didn't do it. And the court held that they were not entitled to judicial review of that. The Chiropractors Association was not entitled to judicial review. I find that very, very curious. But if you say no, you're entitled to judicial review. But if you say yes and don't do it, there's nothing that can be done about it. I find that very, very curious. But that's one of the many interesting cases under these two topics we're talking about today. So now here's the fun part, and that is the variety of procedures. When I first volunteered to do this particular webinar, it was because I was in the midst of promulgating rules from two boards that have existed since the early 70s, certainly existed when 150A was controlling. Now, of course, it's 150B, 150B-4. The boards are sister boards staffed by the same staff. And one of the boards had a request for a declaratory ruling. I knew the statute existed. I'd never had a reason to read it in depth. And when I looked, I realized, yikes. These boards had never adopted a rule prescribing the procedure or the circumstances for which they would issue declaratory ruling. So we got by with no challenge, of course, issued the declaratory ruling. Then I'm like, we've got to fix this. So I was promulgating rules, and that's when I started diving deeply into this. And like any good lawyer, in promulgating the rule, what did I do? Well, all good lawyers plagiarize. That's the art, as Mark Twain said, the art of concealing your source. But for lawyers, we tend to look at other places and not reinvent the wheel. It's not true plagiarism, but that's what I call it. And I started looking at other state agencies' rules to determine what they had and realized there was quite a variety out there. And I took the best of the best and crafted a rule for each of my two boards. But then when first, as I say, when I first volunteered to do this, I got the bright idea that I was going to go through all of these rules, chart them out, and determine also were there any state agencies that were similarly situated like I was with my two boards when I discovered that we didn't have a rule. I was wanted to determine, what state agencies were out there that did not have a rule and may not know they didn't have a rule. And then, of course, I was going to be able to present that to you today. Well, that is an almost impossible task because when we start looking at the procedures here in a moment, you will see the procedures are different. It says shall prescribe and the circumstances, but the procedures are different. But what is truly different is the circumstances. They are all over the place. For some state agencies, I really have to wonder what exactly it would take to fall in a category that they would issue a declaratory ruling. Now, there's some general observations, though, that I will make. When it comes to prescribing the procedures, that's pretty standard. There's some variety in there, but as you can imagine, it's name, address, the statute or rule that the person wants the declaratory ruling on, a concise statement of how the person is affected or how they are aggrieved or how that particular statute applies to them. That's worded a little bit different depending on the rule. But basically how it applies to that person and how they're affected or aggrieved. The question to be answered, obviously, you're going to have to ask that in declaratory ruling, and whether or not the person wants a hearing. Those are the basics. Those are the basics that you're going to find in the procedure. This is the minimum for almost all of them. Almost all of them have this requirement, but some require more. Some agencies actually have a form. It says in the rule that it shall be on the form and that they have a form. Some require verification, like a notary type verification. Some do not. Some, interestingly enough, state how it must be mailed. It shall be mailed, placed in an envelope of a certain size and dimension and mailed through first class mail. I mean, it is that specific in the rules. Others are silent. And even some of these that have requirements about, the size of the envelope and how it's mailed, even say how the mail or the envelope, the container that it is in, has to be marked. And it's supposed to be marked request for declaratory ruling or petition for declaratory ruling. So we do have that specificity. But also, as I mentioned earlier, when I was talking about aggrieved, some is just any person, some is just substantially affected, and then, as I mentioned earlier, some of them are totally silent. But for the most part, the prescription, how it is to be done, is pretty generalized. It's pretty much the same with just a few nuances here and there. But the true diversity, the true range is found in the second part of this sentence, and that is the circumstances in which the ruling shall be issued. That is when we really get into a variety of language. And it is all over the place. You always have to have, of course, some type of argument and whether there's a hearing or not, and the reasons or grounds. But it is actually the circumstances that are get into real detail. The majority of the rules out there have very specific grounds that either bar the person from being able to obtain a declaratory ruling, and for some reason or another, limit it, or say that they are exempt for say that the agency is exempt from having to issue. Of course, the most common one is whether there is pending
Hi, Megan. This
litigation
is
or not.
Christina Young. We're
They
on
have
our way to come pick up Boston, but we're just running a little bit behind schedule, so I wanted to give you all a
Please
heads up.
mute yourself.
There we go. Thank you. Thank you. That
About 12:45, I
the
think.
most common being that it's the subject of pending litigation. Also, there's some
Yes.
very common sense ones in there that things like that they had already issued a declaratory
Thank you so
ruling
much.
on the same topic, or that there is case law or some other type interpretation on the exact same issue. That's a pretty common ground as well. But we're going to look at some of those. We're going to have to do it very quickly to stay on schedule today, but we're going to look at it. The one that I found most interesting in these, and for those that do have a declaratory rule, you probably need to take a look at it because there is some language found in some of these that would never, ever get past one of the attorneys at the Rules Review Commission today. And I will tell you, many of these rules are really old. There's some of them I came across that cite 150A, which of course was the precursor to 150B, our current Administrative Procedures Act. One that I came across cited to 150B-16. I was like, what in the world's that? It's been repealed. So you can tell by looking at these that some of these agencies, and they've even gotten through the periodic review of rules, oddly enough, which I'm really surprised that they made it through the periodic review of rules. But some of these have in the history note that they have gone through that process, and there is still language in there that I, having worked with our excellent staff attorneys at the Rules Review Commission, that they would never let through. The attorneys drive us crazy, all of us as rulemaking coordinators crazy. But we know them, we know the rules, we know what they're applying, and we can pretty much predict as a rulemaking coordinator, somebody that does this a lot, what they're going to object to and what they are not. And some things like good cause. I know that's probably already made all of y'all squirm that are rulemaking coordinators, or good reason, or desirable, undesirable, appropriate, inappropriate, or unappropriate, which I don't think unappropriate is a word, but that I found in one of the rules. So we know those type things would never, ever pass muster today at the Rules Review Commission, but that is the standard. Now, one of these rules we're about to look at, they actually do define good cause, which I presume they got caught in rulemaking and they were told you're going to have to define this. So they have defined it in there. But for the most part, it's not, it is discretionary, totally discretionary. It's either discretionary for the secretary of the department or the head of the division or the director or executive director or administrator or whatever of a board or a commission. It is totally discretionary. That's the one that I find rather interesting reading these, that how many of them have with the word shall in 150B-4 have and allow that amount of discretion in determining whether it shall be issued or not. But even if you look at the appellate court cases, I mean, it's easy just to scan 150B-4 when, in the general statutes and looking at the cases, interpreting it, that how many times our appellate courts have had to determine whether the agency had good cause to deny a petition or a request for a declaratory ruling. So let's look at these real fast so that we'll have time to also look at rulemaking petitions. This one is the Secretary of Commerce. It's very, very broad, but I picked it to include in here because it is so basic. It is so basic here, whether and how the statute applies to a given factual situation and whether it is valid. And the secretary has the power to make such declaratory rulings. And then it tells how it should be submitted. This is about as basic as it gets. And then instead of the setting forth the procedures, it has the section below, it says disposition of requests. That gives you some idea just how old this is. And of course, if you look up here, this is 17, 150B 17 and 16 have been repealed. And it made it through, of course, rule is necessary without substantive public interest. So nobody really took a close look at this when they were going through that process. This is the Coastal Resources Commission, as you can imagine. Many of our environmental agencies have rules. They're similar in many ways, but although they are under one department, there are a lot of nuances. They tend to be the one when you look at the register, and we'll mention the other requirements here in the minute. When you, excuse me, not the register, when you look at the general statutes and the cases cited interpreting this, you'll see that it is a lot of times your environmental agencies that are receiving these declaratory ruling requests on a variety of matters, whether a particular accident is subject to cleanup, as a spill, all types of things on variances that they have in their rules, etc. So they get a lot. So I thought this was a good place to look. So I looked at coastal resources, but here it is, generally. There's the definition, of course, of what constitutes an aggrieved person that I mentioned a while ago. They relate back to that, then cite 150B-4. Then they go through their procedures as well. These are broken up, sort of like commerce, into two rules. And one is the requirement itself, and then number two, it is the specifics. This seems to be a very common theme. This is, if you will note, it's in the 0600s for them. Many of these rules are very early in an agency's particular chapter in the register. It's very interesting that all of them seem to be in the 100s categories, but looking at the size of this agency, you can see why that it's buried a little bit later. But note that it's 0.0602 and 0603. Most of the time for state agencies, they're at the very beginning of that particular statute or subsection in the register. Let's see, we've got next 0.0101. I think this is social services. Yes, I think this is DHR, Division of Social Services. Nope. That's nursing home administrators. Here we go. This is Division of Social Services. I apologize. But this says it shall be by written petition. And that's a term that, we know for petitions for rulemaking, but it shall be by petition. And then, as you can see in subsection B there, it has the basics that I mentioned a few minutes ago about, what has to be in the request. This is very common. And then it lists, this is the particular rule that I mentioned where it lists what constitutes good cause. These are the standards in here for what constitutes good cause for the agency. The next one is the Board of Nursing Home Administrators. This is a good basic rule right here. The petition for declaratory rulings. And as I mentioned before, sometimes they're grouped together. This is a 101, 102, then 103. So you've got your declaratory rulings in here. Very basic, not a lot of guidance on the grounds that they're going to deny it on. And then in a few minutes, when we're looking at petitions for rulemaking, you'll see this one again, because as I mentioned before, oftentimes state agencies group them right in there together at the start of their rules. But this is about as basic as it gets on the declaratory ruling on what constitutes a refusal to grant it, not the grounds for granting it, but what constitutes grounds for refusing to grant it. The next one is the medical board. Again, pretty basic. As I mentioned earlier, usually if it's already been decided somewhere else or it's subject to being decided in the courts, they are not going to give an opinion on it. Also, this very last one here in 6, that the petitioner fails to show that the circumstances are so changed since the adoption of the statute or the ruling. That's a very common one also, that if it hasn't changed since it went through basically the notice process for rulemaking, that if nothing's changed since then, that is a grounds. And then we have one more to look at. This is the Division of Health Services regulation and their rule. So you've got a shall appear for what it shall contain as to the procedures, and then it has a may portion. And then below are the grounds of how the determination will be made. Wanted to just show you how elaborate this can get. This is environmental quality. This is a rulemaking petition. I just put the first page of this up here, but it was a rather exhaustive response on the declaratory ruling as to why they did not grant it. And of course, it ended up being appealed. And so there was a good reason for doing it that way. But they put put together a very, very exhaustive response as to why they were not going to respond. Got another little example in here and both of these are here for a reason. I promise you. The second one is the ordered opinion on a petition for judicial review. This is a rather exhaustive petition. This case came out 2016, 2017 into the appellate courts. This is a pretty well-known case for those of us that are attorneys in practice in the area of administrative law. It was a petition for declaratory ruling from one occupational licensing board to another, where the Board of Physical Therapy the request was made of them from the acupuncture board, vice versa, on a declaratory ruling on what's called dry needling, a particular procedure, sort of like acupuncture, but as to determination as to whether a particular licensees could do it, whether the physical therapist could perform dry needling. And it ended up in our appellate courts and has some really good guidance on declaratory rulings in that case. And that's one reason why I showed it to you, because I'm going to show you here in a moment 3 of what I consider to be major cases on the question of declaratory rulings, and I'll share those with you. But the main point I want to make to you is I hope you have a rule. If you don't have a rule, you need to do it. Of course, it's a mandatory requirement. And if you have a rule that you think is not adequate, that there are shortcomings in the rules, you may want to consider amending that rule to bring it up to what I would call more modern standards of rulemaking. But you must have a procedure. You need to follow that procedure when you do have it. There are some very short time limits in here, so you need to follow those time limits. And even if your rule does not say that you should keep a record, and some of them do, they're very specific about the hearing, about the record, etc. Keep a record, because you never know, just like on the screen here, on the screen share right here with this particular case, you never know if your case is going to end up in the appellate court. It is oftentimes a tactical maneuver, sometimes by, in this instance, another board, sometimes by the regulated industry, sometimes by just a citizen that wants to push a point. It may be a licensee of an occupational licensing board. It might be somebody regulated by an environmental agency or some other agency. There's one of the major cases was under the state treasurer's office on their escheated funds, a question about that, on what they call property finders, property locators that are looking for money that's escheated. And then, of course, they get a percentage. There was a question on that in the state treasurer's office. Seems to be a little esoteric or obscure, but you never know when your declaratory ruling is going to end up in the courts. Here are three major cases just to look at real quick for the lawyers that are on the line. Equity Solutions of the Carolinas, Inc. is the case I just mentioned with the state treasurer's office. It was from 2014. Basically, they submitted their business plan to the state treasurer's office, which sounds like a good idea. It's, you want to come into a state and can I operate legally in your state? And so you submit your business plan and say, does this meet your law and rules? We think we don't have to have a license in your state. That seems to be a very logical thing. And that sounds a lot like advice that I would probably give a client. Let's ask, let's find out. We don't know whether you're covered or not. And interestingly enough, the state treasurer's office refused to issue a declaratory ruling. And the courts held, the North Carolina Appellate Court held that they did not have to, that they had shown good cause as to why they shouldn't have to issue that. Oops, scroll us up one. Affordable Care versus North Carolina Dental Board. Dental examiners, I think this is what you would call one of those tactical type maneuvers, where they asked the question of the North Carolina Dental Board on the dental management agreements. This is not the infamous dental board case from the U.S. Supreme Court. This is one many years before that on what's called dental management companies. And then, of course, there's the acupuncture licensing board versus the physical therapy examiners board that I mentioned to you earlier. All three of these cases have some really, really good discussion about declaratory rulings that can help guide your state agency if you're wanting to amend your existing rule or pass a new one. Okay, let's move real quick before we run out of time, because I do want to leave time for questions. We're talking about next about rulemaking petitions. This is 150B-20. Again, it is one of your mandatory provisions of 150B for rulemaking. You'll see that the wording is almost identical to 150B-4. It says here that each agency must establish by rule the procedure for submitting a rulemaking petition to it and the procedure the agency follows in considering a rulemaking petition. Almost identical language, almost the identical requirements, which is why I think some state agencies have chosen to group or lump the two requirements together in maybe 1, 2, or 3 rules. A couple of them have it all in one rule, and as I say, gets a little cluttered the way it's broken up, but I think this is why they do it, because it is two mandatory things, although they are not on the same topic area. I will say from the standpoint of topics that you've had a number of appellate court cases. Again, if you don't want to read them all, just skim the ones in the general statutes after 150B-4, where they are citing the various appellate court cases interpreting it. And you'll see in different scenarios where the courts have said, no, you should have asked for a declaratory ruling first before you filed your lawsuit or whatever, or no, that's not a declaratory ruling, that's rulemaking. And, it's something different. In fact, that's what happened in the Chiropractic Association case. They said, no, it's not subject to declaratory ruling because it's rulemaking. You should have requested a petition for rulemaking under 150B-20, but they are worded much alike. One interesting thing in here, if you don't know this, and as the rulemaking coordinators here, this will probably be your duty. If a petition for rulemaking comes into your agency and you've never gotten one before, I've never gotten one with any of my boards, my current boards. I did many, many years ago when I was still in the Attorney General's office. I had one petition for rulemaking many years ago. But if you get it 3 business days, that's a really short period of time, but 3 business days, you must submit the text to the Office of Administrative Hearing. And then it will be published in the Register. And for those of us that read the Register on a regular basis, as you know, there are quite a few petitions for rulemaking for state agencies. There's always at least one and sometimes many more in any particular edition of the Register. For the non-boards and commissions, and by that, it just says boards and commissions. We got lots and lots of boards and commissions in the state. Those of us that do occupational licensing, just think of our occupational and professional licensing boards, but there are bunches more boards out there. If you are a non-board or commission, if you're just a straight up plain state agency out here, you have a shorter deadline. Read this right here under B. They must grant or deny a rulemaking petition submitted to it within 30 days. But if you're a board and commission, you get 120 days. The reason for that, obviously, is some of these boards and commissions only meet quarterly. And so they would have to call a special meeting or whatever. But be aware of that uber short deadline if you are a state agency that is not a board or commission. Just be aware of it. But otherwise, very similar. Review, your denial is subject to Article 4, which is the petition for judicial review process in Chapter 150B. Then the actions are pretty similar too. Written statement, etc. But you're supposed to submit the request within 3 days. That's the one that is really tricky that state agencies need to watch for. That applies to everybody. As into the actual procedures themselves, as I say, very much like 150B-4 and declaratory rulings, you have to put your procedures in there. The submitting part, much like declaratory rulings, everybody seems to be pretty much the same on the submitting part. All of them require a draft of the proposed text. I did not find a single rule out there where someone did not require a draft of the proposed text. And that makes perfect sense. If somebody's going to ask for rulemaking, tell us what you want it to say, so we can make a determination from there. So let's look at a few of these real quick. Oops, went the wrong way. Look at a few of these real quick. Went back again. I tried to use the same state agencies. Here, I tried to pick the best of the best, or not the best, really the best of the best. I tried to pick the best examples of the variety that's out there. That's a much better much better way to word what I did. I tried to pick the most representative examples of rules out here. So here's the one from the Department of Commerce. And as you can see, second thing, of course, subject area, but the second thing, draft of the proposed rules, reasons, the effect, data supporting, etc. So this is pretty common. And again, as you will see, it's 0.0101 in their rules, very first thing. And then here's the disposition part of it. Here's an interesting standard, whether the public interest will be served by granting it. That's not going to pass muster. And again, this is one of those, that's 150B-16. It's been repealed. It's been on the books since 1976, but nobody really thought to do anything about it when they went through the process. Social Services Commission, once again, here's theirs, very similar authority, as you can see. Next one here, Division of Health Services Regulations, like we had seen before. And again, very early in their rules, in their chapter, very, very early. And again, they have the shall and may, just like they did for their declaratory rulings. They've taken the procedures out. Most everybody has. If you will look in a lot of state agencies in their rules, in the repeals, they repeal the rulemaking procedures. That was a requirement years ago before 150B and the detail of rulemaking. I mean, it was a requirement under old 150A, and most have repealed it. But it had the procedures set forth before our procedures were standardized. Other boards or other state agencies will just say that they shall follow the procedures in 150B, in Chapter 150B's, Article 1 and 2. And then, of course, as you can see, there's their declaratory ruling at the bottom. And then here again is all their grounds from the declaratory ruling, just like we looked at before. And the final one is the executive. Oh, that's it. That was again, we go back to the nursing home administrators, and this is their petition. Bare bones, basics about all, just if you're looking for a bare bones one for your agency, it's pretty bare bones. Okay, I wanted to leave us about 10 minutes to ask questions if you had any questions. So I want to share one last thing with you, and that is a few other places out there. As I mentioned, this is not the be all and end all. There are other provisions in the general statutes that are agency specific that require your agency to adopt rules. We're not talking about there. We're talking about the mandatory ones that apply to everybody. So these first three up here only apply to occupational and professional licensing boards. They do not apply to the other state agencies. I want to make that clear. 93B only applies to occupational and professional licensing boards that are either your independent boards or what's called a state agency board, a commission or a board or some entity in state government that issues some type of license. This one has to do with freezing funds. This is one of my favorite rules out here are statutory requirements that's ever existed. There's all kinds of reporting requirements that we're going to or that we could talk about forever, but all kinds of reporting requirements. The legislative staff determined that no one was keeping copies of those reports, including the legislative staff. So they stuck a little law in that says we'll freeze your funds because we didn't keep a copy of what you sent us. I just love this statute. The next one only applies to your community colleges and occupational licensing boards about apprenticeship training. Mandatory that you have rules on apprenticeship training if you have apprenticeships. And then this one has to do with waiving continuing education requirements, payment of any fees, any other requirements, et cetera, to maintain a license by a member of the armed forces. It's much longer than that, but we won't go into that. But that whole 93B-15 has to do with the military. And then here is one more, and it's only going to apply to these folks again, occupational licensing boards, because occupational and professional licensing boards, but not state agency licensing boards. And that is the conduct of hearings under Article 3A, which is generally your independent occupational licensing boards and just a couple of other entities. But again, lots of other mandatory stuff that may be in your state agency bills. So I've run over. I'm going to turn it back over to Catherine to open the floor to any questions that anybody might have.
Yeah, thanks, Jeff. That's great. We just have one question in the chat right now, and we may have touched on this a little bit, but if you have more you'd like to add, I'll give you a chance. So the question is, are any agencies, boards, councils, or commissions, Article 3A, et cetera, excepted from the declaratory ruling requirements of 150B4, where there are more specific statutes addressing the procedure for the panel's formal interpretations of its rules, appeals, etc.?
My opinion, when we have, and there are lots of instances for state agencies and especially these boards where there are more specific requirements elsewhere. You can use the general process of statutory interpretation and which has a priority based upon the date. You could do that. But generally, I have recommended to my clients that when there are other statutes elsewhere covering something, that you follow those, the more specific ones that may be in your agency's enabling legislation. For instance, when you look at the public records law of Chapter 132, there are lots and lots of state agencies and lots of boards, et cetera, that have provisions that actually make their records or exempt their records from the Public Records Act. And so you look at the Public Records Act and you say, yep, they got to do this. But if you look at that specific board's law or commission's law or state agency's law, their enabling legislation, it'll say, something else. So I would follow that. There is nothing definitive that I know of appellate court wise that says which would apply, but I think I would apply the more specific rather than the generalized when it comes to the procedure if there's a separate statute. But also you've also, you could get the argument back that, oh, this one was passed after that. So it has precedent.
All right. We got another question here from Anne. Were there any provisions in either type of mandatory rules that you thought would not pass the RRC?
You mean in agency rules? Were there other provisions? Oh, heavens, yes. Yeah, some of the wording, I've read so many rules through the years, being on the Rules Review Commission, doing these type continuing educations, getting questions from clients, getting questions from rulemaking coordinators, other attorneys, et cetera. Yes, and you can almost inevitably look at when the particular rule was passed, and you can kind of ballpark it whether it's probably ever been amended, hence gone through a more modern process. But yes, quite often. And I will admit, I'll try to look at both sides of the coin. I will admit, oftentimes state agencies do not submit a rule because they do not want it revised by the staff. So they'll just promulgate a separate rule when the logical place was to put it in the larger rule. We know that's done. It's everybody knows that's done. It's just one of those things that's done, and we won't debate the reasons whether it's good or bad. But you can almost look at a rule oftentimes and tell when it went through the process by the language that's in there. And yes, and in almost all of these, there was always something I'd be like, I'm not so sure that would make it through under what I call modern standards, the current guidelines used by staff attorneys to look at rules.
And Anne has a follow-up question. Do you consider as a mandatory rule for everyone the 150B-19 requirement that you can't adopt a rule to waive or modify a requirement unless there's also a rule with guidelines for waiving rules?
Yeah, I do. Yeah, I have looked at that before. I've had sometimes I like having that because I have boards that want to make a one-time exception. And as an attorney that advises boards and tries to, to make sure they do what they're supposed to do, that is a good place to hang your hat sometimes as a lawyer. And it prevents them from doing one-time exceptions because, as they say, once you break a rule, you don't have a rule. And so that it gives you a good place to kind of hang your hat as a lawyer. But yeah, as a general rule, I would agree with that. Yes. Yeah.
I've got one more question for you here. If an agency did not have a petition or a declaratory rule, what would happen in the event someone submits a petition or declaratory ruling request to that agency? Those processes could still be seen through, right? Just without the clarity and specific procedures that would be provided by an agency's rules.
I laughed when I realized where you were going with that question. That's exactly what happened to me. That's exactly what happened to me. And if anybody caught it at the very first when I, admitted what happened, I said we, plowed forward because we couldn't meet the deadlines. We couldn't get a rule through and meet the deadlines. We plowed forward, and thank goodness the person did not challenge it. I think they were happy with the ruling. It was I think it was a good result for the declaratory ruling, and they didn't challenge us. So I managed to escape. I mean, here I'm having confessional right here, but I used what was in the statute, some generalized guidelines from looking at other people's rules, and moved forward. So that I could, or not I, of course, I was left to write the declaratory ruling, but so my board could answer them within the appropriate amount of time. But yes, I just used what was in 150B-4 and what some other boards did with the guideline, and we granted the request and we moved forward. So we didn't have anybody to challenge us. But I will admit I was a bit nervous when it happened, when I discovered that, and it wasn't under my watch that the statute was passed and it wasn't caught. But I can't say for certain that maybe I wouldn't have caught it when the legislature passed it. Or maybe it wouldn't dawn on me. But yeah, I just moved forward under 150B-4 with the bare minimum that was in there without any specific procedures. And of course, granted it. Now, if it denied it, I'd have been up the creek.
Yeah, it seems like if there's no rule in place, then you're kind of stuck having to approve it, because if you're using grounds that aren't there to deny it, it's going to be highly subject to appeal, right?
Exactly. I agree 1,000%.
Well, I think that's all the questions we have here in the chat. But again, folks, if you didn't get a chance to talk with us about any questions you have, you're welcome to reach out offline. We're always glad to talk about rulemaking with you. But I'm going to go ahead and close this up since we're at 1 o'clock. Just a reminder that you will be receiving an email from the Bar Association with a link to this recording and Jeff's presentation today. And don't forget to register for the March 18th CLE, where you can hear directly from the chair of the RRC and the codifier of rules. It will be a really great presentation, so we hope you can make it. Thanks for attending today, and any feedback you have on topics or substance of these presentations would be very much appreciated. So thanks again. Take care, everybody.
Thanks, everybody.